Welcome to Case by Case. This is a podcast brought to you by Calum, Cheyne and Luke Zadkovich from ZFZ. How are you today, Calum?
I'm very good, Luke. How are you?
I'm very good, very good. I'm looking forward to getting into privilege today.
Yeah, this is an interesting one. I went through the judgment to find the oldest piece of law in this judgment, and it dates back to 1876. And the reason I looked for it is that I couldn't believe that this is an untested point.
Yeah.
And I had to, this law's existed for hundreds of years.
It's amazing to get to where we are today, and this point directly has not been answered. And to have the English Court of Appeal asking some very fundamental questions, I think, and coming to a decision. Some of the fundamental questions that this case asks are, one, is the identity of those authorized to give instructions for clients privileged? Secondly, I think there's a fundamental question about what is the nature of the privilege? What is it aimed at? Is it aimed at facts disconnected from communications, or is it related to the communications themselves? Fascinating questions. And then the last question in there, Calum, was this Canadian concept of a zone of privacy. Does that exist under English law principles?
It's a really interesting case. And as with all of these things, when you get a judgment which is really neatly put together, you go back to first principles. And here we're talking about privilege. So really what we're talking about, and what the judge makes clear, is we're talking about circumstances in which the court will essentially decline to see relevant evidence for policy reasons. Effectively, they say for certain reasons of policy, it's appropriate for us not to consider certain categories of evidence. And I think when you frame it that way, we'll obviously do our normal thing and go through the whole case. But I thought that was an interesting point to emphasize, and it colors some of the limitations on privilege that we see in this decision. Yeah,
and there's this interesting tension, isn't there, between the purpose of litigation privilege in the first place around letting a client feel or know that they can communicate with their solicitor freely and not be worried that something that they're going to say to their solicitor is going to be held against them and later disclosed in the proceedings. So you've got this rationale on one side being weighed against a test around, well, how relevant is this information? Is it important for this fact to get out into the litigation itself so that the parties can argue their respective cases? And it's not just one objective here. There's a couple of kind of objectives which are being balanced or weighed against each other.
Exactly, and it makes it fascinating, and it does make it surprising to me, as I said at the top, that this just hasn't come before the court before. This is the first time the English court's making a decision on whether or not it's a valid ground text to exercise or to grant privilege over documents on the basis that they would reveal the identity of the instructing party. Fascinating.
It sure is. Well, let me give the case citation so we all know what we're talking about here. This is a very recent decision. It was handed down a few days ago on the 10th of November, 2022. This is an English Court of Appeal decision with 3 of the Lord Justices sitting, Lord and Lady Justice sitting. It's the case of Loreley. Loreley, I think, is that how you'd pronounce that? Or is it Loreley?
Loreley, I think I'd go for.
Loreley? Okay, let's go with Loreley. Loreley Financing as the appellant, and Credit Suisse Securities, Credit Suisse International, and a couple of other Credit Suisse entities as the respondents to the appeal, also the defendants in the underlying proceedings. Fascinating underlying facts to the case, not just the privilege issue, but the underlying matter, which we'll touch on in a minute. The justices sitting on this were Sir Geoffrey Voss, Master of the Rolls, Lady Justice Nicola Davies, and Lord Justice, you know who, Males. We say that because if you've not listened to us before, we very much enjoy reading Lord Justice Males' leading decisions, and we've got another one here. I think he is prolific. I think it's fair to say, Calum.
He is. He's putting out a lot of very good judgments. They're just great examples of how to write legal texts, and I say that with every respect. As someone who is developing my skills, and Lord Justice Males is someone who's just at the very top of the game in writing these. So I just love reading them.
I do too, and there's always one of those moments for the instructing solicitors or counsel who are appearing before him, where there's something that he's got in there that they have not thought of. Maybe not always, but very often there's a point in there, the cringe moment where you're like, oh, we didn't think of that. And yet in this case, it became determinative. We'll get on to that, but it's another Lord Justice Males classic, if I may say, and with, of course, the greatest of respect. And the neutral citation number is 2022 EWCA Civ 1484. Go check it out if you're interested in reading the full judgment. But we will today give you a summary of it, as we tend to do. For those listening for the first time, Calum and I just read the case, don't talk about it beforehand, jump on here, give a factual summary, get into some of the law and the submissions that are made, and talk through, analyse the decision, let you know what we think of it all. And so without further ado, let's jump into the facts, Calum?
Yeah, let's do it. So we have here a claim between Loreley and CS, and Loreley are claiming against CS for fraud. They're alleging fraud around the sale and purchase of a number of CDOs, which are these collateralized debt obligations. And anyone who's looked into the 2008 financial crisis in detail will be familiar with the prolific use of CDOs to package residential mortgages and sell them all off. I think it's basically the plot of The Big Short.
I was going to say, this is The Big Short, right? I can't believe these things are still kicking around. And there is a time bar question in there, isn't there? Which really goes to what we're going to talk about today, in a way.
And actually, I was looking into the facts of this case, and the sale happened in 2007. So this is really Big Short material. You've got $100 million worth of CDO. Obviously, that went through the floor. There's now the party that purchased the CDO alleging fraud. This is right in that Big Short spot. Hey,
by the way, just on that, I know there's this argument here about, well, time shouldn't run out when it usually does, and it should be extended because the alleged dishonest misconduct was only discovered at a later point. When did the Big Short movie come out, right? It wasn't in January 2017, was it, when this was alleged?
Exactly. So that's exactly why this becomes such an issue, because Loreley are alleging fraud, and CS is saying, no, it doesn't matter because you're time barred. They're presumably denying it on all sorts of reasons. But one of the defenses is there's a time bar defense. So Loreley say, well, we get around the time bar defense because we didn't know about this fraud until The Big Short came out. Or in fact, they're probably arguing something else. But they didn't know about this fraud until sometime later on. And now they've brought the claim. And CS are saying, well, Loreley is an SPV. And Loreley's directors are these kind of appointed commercial directors. It's a Channel Islands company, and I think most of our listeners may be familiar with these kind of directors in the Channel Islands who can authorize they can authorize board resolutions, and they kind of work as professional directors for these financial services companies. Particularly investing in real estate is quite common, and so Loreley say, well, our directors didn't know anything about this fraud until much later on. And CS are trying to say, but you as a company should be taken to have the knowledge that the ownership entities of this SPV had. And the ownership entities are two banks. So to try and make that point, which is you are effectively owned and controlled by these two banks, despite your nominal directors based in the Channel Islands, we don't care what the nominal directors in the Channel Islands knew. What we care about is what the banks that actually own this SPV knew. And we say, CS say, that we can prove that their knowledge should be imputed to Loreley because they are the parties who are leading this litigation. And one of the ways they want to prove that is they say, we get to see your engagement letter, and you cannot redact the engagement letter to take out the people who are instructing you, because that's not privileged. And it's not privileged because it's relevant to us. It shows, we think as CS that it will show the court who is giving these instructions. We suspect that it is these ownership entities, these two German banks. We know that those German entities knew about the facts giving rise to this alleged fraud at an earlier point in time. If that's correct, the time bar defense doesn't work, or the defense to the time bar defense doesn't work. And that's how this all comes to light. So CS contests the redaction of the details of the parties appointing in the engagement letter. They also contest the claim for privilege over certain other documents that aren't listed. They just referred to as other documents in the judgment. And finally, they ask, as this Part 18 request, a request for information on who are the instructing parties. So there's kind of these two of them are very similar. Two of them are kind of contesting privilege. But there's also the second limb here, which is whether they can request that information on top of. Do you see what I mean? Like there's the two issues. One is the application of the law of privilege. The other is request for information.
Yeah, exactly. And just to kind of tease that out a little bit, I think there's really kind of two requests that are being dealt with here by the court. One is in respect of documents. That's the engagement letter, and in particular, a redaction made in the engagement letter to remove the identity of those instructing Loreley. So that's one of the requests. The second request is a straightforward request for information, request for an RFI, as we call them, request for further information pursuant to CPR 18. And that's just a straightforward request for information asking who are those who are instructing Loreley, and what individuals at the financing institution that may sit behind Loreley, who is it individually at that institution who is instructing Loreley. And so that's just a straightforward RFI, request for information. And so the court then goes on to deal with privilege and looks at this question of whether asking, as I mentioned at the outset, asking who is the individuals providing instructions, whether that is inherently privileged, whether that is just like in this so-called zone of privacy that was argued by the appellant, and a matter that just should not be requested. And as we're going to get into, the analysis or the argument is around, is that inherently privileged? Or when you're looking at litigation privilege, and we touch on legal advice privilege as well, but just thinking about litigation privilege for the moment, does that actually target the communication, right? The communication between solicitor and client. And if so, you look at privilege through that prism, number one, is it a communication? Two, is it a privileged communication? Or is it a secondary document that refers to privileged material from a communication? But it's looking at it through the prism of a communication. So that's all to deal with the documentary request. Then you've got this additional point that we referred to earlier that the court raised on its own, and it wasn't a matter that was pleaded at that time at the hearing, and that is whether this request for information, whether it not only just asks for privileged information, that is its identity point, but is it proportional? Is this the type of information request that should be made? Should you be allowed from a proportionality question to ask who's providing instructions for you? Because you can just see and you can see why the court was concerned about this, because this kind of question will be question number one in every single case. if there's not some proportionality or some guardrails put around it, it's the type of question that could be asked in every case. Is it an appropriate question is probably a better way of putting it. Now, at first instance, this was all argued on privilege. This was a privilege case all about is asking, whether through the documentary request or through the request for further information about the identity of those instructing Loreley, is that inherently privileged? And that's what the parties argued at first instance, and that went in favour of CS. We then get into the Court of Appeal, and that issue around this inherent privilege on client identity is the main thrust of the argument. And then it's the court that then goes to look at a point that wasn't argued. And I think that's worth kind of talking about a little bit after privilege, Calum. But yeah, so we're now in the Court of Appeal, and we're going through some of these very old authorities on what is the nature of litigation privilege. What's the origin of it? What's the reason for it? Maybe that's a good place to start in the analysis.
Yeah, I think it is. And we go back, as I say before, to this nearly 150-year-old case of Anderson and Bank of British Columbia, where the classic statement of litigation privilege is set out by Sir George Jessel, Master of the Rolls, back in 1876. I think I'll read the whole thing. Maybe I'll read it quite quickly, but it's a good passage to understand. And he says, "The object and meaning of the rule is this, that as, by reason of the complexity and difficulty of our law," and this is back in 1876, I dare say it's got slightly more complicated since then. There's a bit more of it since 1876. Anyway, he goes on, "Litigation can only be properly conducted by professional men. It is absolutely necessary that a man, in order to prosecute his rights or to defend himself from an improper claim, should have recourse to the assistance of professional lawyers. And it being so absolutely necessary, it is equally necessary, to use a vulgar phrase, that he should be able to make a clean breast of it to the gentleman whom he consults with a view to the prosecution of his claim or the substantiating his defence against the claim of others. That he should be able to place unrestricted and unbound confidence in the professional agent, and that the communications he so makes to him should be kept secret, unless with his consent, for it is his privilege and not the privilege of the confidential agent, that he should be enabled properly to conduct his litigation. That is the meaning of the rule."
Just pausing there. One moment. Whenever I read these types of passages from 1876, I'm sure you have the same reaction. It is so jarring in this day and age to be reading about men and only men, a gentleman. And, I think, I know there's a lot of distance still to go and a lot of improvement to do in kind of gender equality and what have you. But for my first reaction when I read that, to be jarred by the gender, bias, if you like, in the language that's used. Of course, it's not necessarily meaning that, but the language that was used it shows like how far we've come. But I know we've got a long way to go. I just wanted to say that because we see that a lot in some of these old passages.
We see it a lot in old passages. We see it in modern contracts too. The arbitrators shall be commercial men. It still exists, but it's still equally jarring. I know that on a number of our files, we've had these commercial men arbitration clauses and often have appointed female arbitrators. And obviously no one's taking the point that they're not entitled to. But then if no one's taking the point that you're not entitled to, why is that formulation still find its way into contracts? It is bizarre and it is jarring. When I had the same thought when I first read through that, conducted by professional men, and then a gentleman should be able to substantiate his claim. It is extremely gendered. It
is absolutely necessary that a man.
Yeah. It is.
Anyway, back to the point. That's an aside, but I feel like we need to say these things because it's important. It's important to continue to push the boundary of this and continue to move the language that we use in the right direction. And I'll get off my soapbox in a minute. But if we don't pick this up, and if we do just continue to use this kind of parlance, it won't change quickly enough.
Ignoring the heavily gendered language, what it's really saying is that a person who wants to bring or defend a claim has to be able to go to somebody, specialist, and say, this is my argument, warts and all. Am I in a good, strong position or not? And it's for that person, that lawyer, to say, okay, well, these are the bits of your argument that we need to be presented to the other side. This might be a problem. This might be a problem. And that's necessary for lay people, I guess you could say, to be able to conduct litigation. Otherwise, they would be entering into this mess all on their own without any ability to filter out what they can and can't say in the litigation.
Yeah, and there are shorter quotes from other cases, like the Three Rivers case. A man must be able to consult his lawyer in confidence, since otherwise he might hold back half the truth. The client must be sure that what he tells his lawyer in confidence will never be revealed without his consent. And this makes a lot of sense. And there are a bunch of other cases that are referred to with similar kinds of quotes. But it's all about this creating an environment for the client to be able to speak truthfully, freely, without having to worry about whether what he or she or other says to the solicitor is going to get out one day. And this isn't, this can have massive effects on people's lives. And the privilege is such a universal principle in the way that solicitors and clients deal with each other, that that's such an important fundamental principle. And why the court goes back to this is to look at, well, what is the nature of litigation privilege? What is it looking to protect? And if you've picked up kind of the nature of what we're describing, it's communications. It's the process by which a client is informing the solicitor about relevant information or facts or strategy or what have you, and they're communicating this to the solicitor. So the way that the privilege has developed is to protect the communication between the solicitor and the client. And that's really important, central to this decision as well.
The next step down that line is that you're protecting this communication between the lawyer and the client. And then in certain circumstances where we do have law, they are also protecting identities of people. So for example, one of the cases that's referred to is the China National Petroleum Corporation against Fenwick Elliott case. This is a 2002 case, so substantially more recent. And in that case, they found that correspondence relating to the identity of a potential witness was privileged. And they said, okay, so in this case, Loreley said, well, the identity of a person is therefore something that can be privileged. And they wanted to extend that and say, here it's not the identity of a witness that's privileged. Here it's the identity of an instructing party, which is privileged. But it's the same thing. We're talking about the identities of individuals. I have to say, I didn't actually think very much of that argument, Luke, because it is a very different situation identifying the instructing party versus identifying the witness. Because if you identify the witness, you know what the witness may want to say or may not say. If you identify a witness and then that witness doesn't stand, the other side knows that witness, presumably in the evidence gathering phase, that witness said something that they thought, okay, actually maybe he's not, she or she's not the right witness. It's very different to the party that's sending the instructions.
I think there were a few instances of arguments that I thought ultimately the appellant lost, but where the arguments were just stretching. There was this argument put about zone of privacy, which I mentioned earlier. And this is a term that comes from, I think, Thankey, the Law of Privilege, 3rd edition 2018, para 3.10, if you're interested. And it's derived from this Canadian case of blank v. Canada Minister for Justice 2006. I've not gone to that case and looked at it. But it's the concept that there's there's like as the words suggest, this zone of privacy where you can't even ask, or you can't even ask for documents within certain areas of the other side's preparation for litigation. It's almost like the litigation is either contemplated or in place, and there's this whole kind of realm of information that you just can't get at. You can't try to ask for information related to it. It's like a protected zone. And as you know, I don't know how it was argued in the Canadian case. So all I'm going off is what's said here and looking at it from an English law perspective. But it is quite a broad concept, and it's difficult to wrap your head around. What is that zone? How do you define that zone? Where's the limits of it? You know, if you're going to start drawing your dotted line of zone of privacy, how do you get the pen out and draw that dotted line? And the court didn't like it really, and said that concept does not exist under English law.
The one thing I would say for that concept is it does make life easier when you're doing the disclosure review. If you can say this document is either privileged or not privileged, whereas I feel like if you start to say, well, the document itself, this communication is largely privileged, but actually let's look at each individual line, each individual sentence, and see if that bit's privileged, then I can see why, for policy grounds on just the cost of litigation in general, there would be some sympathy for a zone of privilege argument. Yeah,
but haven't you hit on exactly the point about privilege? That privilege and the ascertainment of privilege, or the assessment of whether something is privileged or not, is not a black and white question. And I think it's a really, really important point. And I'd say one of the main takeaways from not just this case, but for anyone dealing with privilege. And that is, sometimes documents that you might at first blush think, this is between a solicitor and client, it's privileged. Or this refers to XYZ, that's quite a private issue, that's privileged. And in practice, just out of pragmatism and practicality, when you're trying to work through privilege issues at a threshold first level, that is kind of the approach you initially take, and then you might drill down on it, or if the other side takes issue with it, then it becomes a more nuanced debate. But looking at it from a formal, legal, technical perspective, you do need to look at the nature of the privilege, and you need to look at what type of document that the argument is being had over, what's in the document, what are you trying to protect, and it's a really contextual, detailed, close analytical process, and it's not a broad brush approach at all. And I think you're right. It would be great if we had a list of documents to say X, Y, Z. They're all within a zone of privacy. When it comes to the next disclosure round we're dealing with, we'll stick this document in that bucket, we'll stick this document in that bucket, and we'll crack on with things. It's not the way to deal with privilege.
Yeah, it's not how it works, and that's borne out in the in what I think is the key paragraph of this judgment on litigation privilege, which I think is paragraph 38, where Mills says, I conclude, therefore, that in order to determine whether litigation privilege extends to the identity of the persons communicating with a solicitor in relation to litigation, it is necessary to consider whether disclosure of that identity would inhibit candid discussion between the lawyer and the client. If so, the identity of such persons should be privileged, but if not, to extend privilege to the identity of such persons is unnecessary and may deprive the court of relevant evidence needed in order to arrive at a just determination of litigation. So he's saying not only is it, and I think the gloss on this is that it's likely that the identity of the person communicating with the solicitor will not be privileged, but it's not black and white. Even in this narrow, even when we get down to this very, very narrow point of looking at, does privilege extend to the person instructing solicitors? Well, Mills tells us not necessarily, but also not certainly. You have to look at it.
Well, hypothetically, what are you trying to protect around the identity of those instructing? Like, give us an example. And I chuckled when I first read it. Before I even read Lord Justice Males's comments on the example. But when I read the example, I'm like, well, it could be, imagine if there's an individual who is head of settlement strategy at the client, and if that individual's identity was disclosed to the other party, it may suggest that the client is thinking about settling the case. And there was another example around, well, an individual whose only job is to assess quantum on a case, it may suggest that they're not worried about liability and they're looking just at quantum. I don't have the exact quote right here. I'm going off recollection, but the Males just said something. In 40 odd years, I've never heard of an individual called head of what is it, settlement litigation or something. Head of litigation settlement.
He then goes on with the completely acerbic take of, if these are the best examples of the problem which Mr. Lord asserts would arise, that suggests to me the problem does not really exist.
I love it. This is why we have developed the Lord Justice Males fan club for lines like that. we could probably get a bunch of these and maybe even make I don't think we're yet at a mini book. But we could make a pretty cool poster or something with some of these.
We could probably make a nice mouse mat.
Yeah, exactly. We should do that.
If anyone wants something to really wind up their family over Christmas dinner, then that's a nice one. If this is the best example of the problem that you say arises, then it suggests to me the problem does not really exist.
I love it. I absolutely love it. I reckon we're getting close, very close to developing our first merch for Case by Case podcast. A mouse mat with Males quotes. Anyway, I don't know where we got to. I got completely sidetracked. But yeah, it's this point, isn't it? It's this point around, that what are you trying to protect? And that's what I was going to say. He goes on to talk about this language without more, and I thought that was a nice turn of phrase. Because I don't think this case stands for a principle, and this is what you were saying, that the identity of a client in a communication could never be privileged. I think what it's saying is there needs to be something more. You need to have a head of, settlement strategy at your client, and you need to set that out in a witness statement, in an argument around privilege, and you need to explain this, getting over the without more threshold that the court refers to, and explain why would the identity be privileged? Why should it be privileged in this case in that communication? Now, maybe there are perhaps not as far-fetched examples where you might be able to satisfy that. And again, it just emphasizes what we're saying about privilege. It's going to turn on its facts. It's going to be a case-by-case analysis. Sorry, bad pun. And that's how you need to look at these things.
So I think we can probably tie up the privilege question in this case, which is that it will come as no surprise that Males said effectively, no, in this case, that information is not privileged, or at least those redactions cannot be maintained because there's no good reason for maintaining them. So you have to give us the unredacted version of that document. And what I liked about the judgment is that you have this very nebulous discussion on the nature of privilege, on the way that privilege works, and then it ties back in over the last couple of pages and it says, okay, so what does all of this mean? Where have we got to with all of this discussion? First things first, you are not entitled to those redactions in that letter. And you have to give them the unredacted version of that letter, which presumably has details of the instructing party. Secondly, I want you to go away and I want you to think about all the other documents that you've withheld from disclosure or withheld from inspection on the basis that they're privileged, and apply this judgment to those documents. And presumably that will lead to inspection of more of these disclosed but allegedly privileged documents. And then finally, separately, and it's completely right to separate it, and it was interesting that it hadn't been separated kind of in argument, but separately, what does that mean for this Part 18 request for information?
Just before we get on to the RFI request 17, I just wanted to emphasize that exercise that the court told the parties to go away and do, as you've very eloquently explained, Calum, was about communications, right? It wasn't about this concept of, is there some information that is or is not privileged around the identity? It's look at the communications. This privilege over identity does not exist. Now go back and conduct the type of contextual analysis using the privilege principles set out in this decision to look at communications and then apply it through that communication lens. Yeah, and so the RFI, I might just go back, if I can find it, to the language of the RFI. I think I'll just read that out because it's quite important. These RFIs often turn on what is being requested. So request 17 is the number in the list of RFIs. I think it may have even been the last of the 17 requests. And so this, as we said, is a request for information pursuant to CPR 18. So it reads as follows. Paragraph 1043B of the defence inter alia alleges that KFW may be providing instructions to RPC, that's the law firm, on behalf of Loreley 30. Please therefore confirm whether or not individuals at KFW provide instructions in relation to this litigation on behalf of Loreley 30. So Loreley 30 is the entity in the suit. KFW is the entity sitting behind the SPV Loreley. Okay, that's my explanation, not in the RFI. But the RFI then goes on to say in brackets, for the avoidance of doubt, this request does not seek disclosure of the underlined content of any communications which are subject to legal professional privilege, seeking at most to identify the individuals who engaged in such communications, which fact is not itself a communication or subject to legal professional privilege. So the key words we're looking at here confirm whether or not individuals at KFW provide instructions in relation to this litigation on behalf of Loreley 30. Now, the issue is that type of request proportional, appropriate, necessary to deal with the issues in the case?
It's a close reading of CPR 18 in the practice direction, which says a request should be concise and strictly confined to matters which are reasonably necessary and proportionate to enable the first party to prepare his own case or to understand the case he has to meet. So the question is almost kind of taken in the negative. It's do you need this information to prepare your case? And Males looked at the submissions and said, well, you've actually pleaded this. You've made a pleading and you've advanced a pleading which says that the instructions were coming from KFW. So you can't now turn around and say that you need this information in order to make that pleading, because you've clearly already satisfied yourself that you're in a position to make that pleading without it. That seemed to be that was my read of essentially how Males came onto this, and he said, it's therefore not necessary.
It's an interesting one though, isn't it? Because if it's a fact in issue, right? If it's a fact you're trying to prove, wouldn't documents going to that fact be disclosable? Wouldn't that fall within a relevant test? At first blush, absent the language in the CPR, which of course we need to look at, but at just first blush, you'd think, well, this is a case where who knows what is a relevant fact in issue. It's not just you want to get at, some sideline issue here. This is a fact that's being debated. And what is the effect of that? Because remembering the underlying dispute here is about what we've got a case that's been brought very late in time. The defense to the time bar argument that the defendant's running, so the defense by the claimant, is that we only found out about this very late. And the defendant is saying, well, the company that sits behind you, SPV claimant, did have knowledge. There were people at that entity that had knowledge, and that knowledge should be attributed to the SPV. So it's not like we're dealing with, and this is why it's so fiercely contested going up to the Court of Appeal, of course. It's not like we're dealing with a completely ancillary issue here where it's frivolous or it's off the reservation completely. It is in there, right? And I just got the sense that there was more of an overriding floodgates concern, actually, where if this type of request is allowed to go forward, what does it then mean as an RFI? So not as a document request, but as an RFI that can be asked in the abstract, can be asked, in the broad sense. Is the court worried about, well, okay, if we let this go through without some kind of guardrails, without some kind of comment on it, where does that lead? And I thought that might have been what was driving the decision here.
Yeah, I think it's a good point. And I think it's as you say, it's an important distinction between the request for information and the document disclosure, because the request for information is asking the opposing party to confirm something or to give some response to the request, which is distinct from them having to disclose evidence. So if there is evidence that shows that KfW are providing instructions to RPC, then to me that is relevant, and it seems like it falls within the scope of relevance, and those documents on the basis of this judgment will have to be disclosed, given what the Court of Appeal has said to the parties, go away and disclose the rest of the relevant documents. But it's then the second, it's beyond that. It's then saying, okay, are we also required to give you information? Are we also required to tell you the answer to this question? And I can see why the court said, no, you're not required to do that, because they've advanced their case, you advance your case, and the evidence will come to light that proves whether one of you is right or wrong, and the court will form a view on the balance of probabilities, who is right or wrong on this issue. So you don't need to confirm anything. That's just something for evidence in the ordinary course. It becomes an evidential issue rather than something where where Loreley were required to kind of pin their flag to the mast. And I also think, as you say, there's a very sensible floodgates rationale behind that decision. It doesn't.
Yeah, I think you're right. And as you've been talking, I think it's crystallized in my mind here a bit of what the court's driving at. The request itself, so the request 17 for further information, was not narrowly drafted in the sense that it was asking for anyone really who could provide instructions on behalf of the SPV claimant. Not necessarily who has, not necessarily who the engagement letter was sent to, and it was quite broad in that sense. You could argue that it's narrow, but I think the court was picking up on the fact that it's a broader request. It's not like, had the RFI been, please confirm who the engagement letter was addressed to, for example, and we don't need to see the engagement letter. We're only asking for the engagement letter to find out who the identity of that party is or that individual is, and it was restricted to that. It might have got through, right? It might have got through because it also would have avoided the need to disclose the engagement letter as well, and it seems like that's all that they were driving at anyway. That's a narrow request. That's for a fact. That's for an indisputable fact. But a question more nuanced around who has instructions. Well, what does have instructions mean? What authority level should we be talking about here? Should we be having to explain that, yes, the individual claims handler or commercial person has primary authority, but then they report internally to manager X, and then a matter like this has $100 million at stake, so it actually gets reported up to the CEO. Do we have to explain the chain of authority at our side to give a proper explanation? Like, you can see when you start to unpack it, it is actually quite a broad question. And as you put it then, I really like that explanation, Calum, because, if you don't mind me saying, because RFIs are supposed to be about facts that are not going to be proved one way or the other by the evidence. That's the nature of that's the process, right? The process is you're pleading a fact. You're going to One side's going to adduce its evidence, the other side's going to adduce its evidence, and then there'll be a decision on the fact. You're not expected to almost give an admission or concede an argument or concede an evidential point in RFIs. It's not the point of them.
Yeah, exactly. And then you go back to the practice direction. Do you need this information? And as you're saying, it becomes more clear. Do you need the entire authority structure of the people that you're suing or defending a claim against in order to plead a case? You don't need it to plead the case. Well, in most situations, you won't need that to plead your case. You can plead the case, and then the evidence comes out in the wash.
Isn't it interesting, though, just stepping back? So obviously the court ultimately struck down this request for information, said it was too broad, not reasonably necessary and proportionate. And I think there's a line saying that the court actually would discourage this type of... I would not encourage such requests, quote unquote. It was unnecessary and disproportionate. Pretty clear language there from the court.
It's pretty strong wording, and it's pretty forthright. Gives some good direction around RFIs, and don't ask for more than you can reasonably expect to get. I think is a fair summation.
I think that's right, Calum. And also, isn't it interesting where we get to the Court of Appeal and a point that was not focused on at first instance, not focused on in argument. The court did raise it itself in argument at the hearing, and then there was some post-hearing briefing on it, including an amendment to the arguments by the appellant, the claimant, to their original application, and that was allowed through. And so the RFI was struck down on the basis of a post-hearing amendment, even though the respondent said it was too late and shouldn't be allowed in. Thought it was very interesting, actually, procedurally. But my point is, isn't it interesting how so often, maybe not so often, but we do see, the more and more we do this, that arguments that might not be the focus at an earlier stage become quite large in the appellant stage or at some higher stage. And is there not a lesson to be learned in that, to say, look, at each stage of litigation, let's sit back for a moment. I know we're going down this inherent privilege argument route. Let's just sit back at some point. And KCs are excellent at this. We know that from experience. It's often what they do because they have to stand up and argue it before the court, and they're thinking, well, if I'm looking at this as a judge, what would I be thinking? How would I be thinking about this afresh? And so they often do this. We see it as solicitors. They often will do this, and we try to do it ourselves. But I think it's such a good example of where at an earlier stage and it's really hard. I'm not trying to, please don't take this as criticism of anyone involved. It's not intended to be, because this originally came up in a CMC. And at a CMC, a case management conference, where there's all sorts of documentary issues and privilege issues running around, throwing around, full argument like you're going to get at a court appeal level is not going to be had, right? It's just not the, but then, it does get argued, right? And then privilege becomes the main focus. At some point, sitting back and saying, well, hang on, do we have another argument in this? It's just, I found it's a really important lesson that we see time and time again, and one to
and it's the refinement
emphasize.
Of the arguments as well. As you go up through each stage, the arguments get refined, and everything gets pared back, and you then spend a lot of time focusing on a very narrow point. So I think it's inevitable in some ways, but it's always interesting to me when you see these things go to trial, and when we see our own cases go to trial, there's always some points that pique the interest of the arbitrators or the judge in a way that you go, oh, okay, they're really interested in that point. Didn't think they'd be so interested in that particular point, or that thing's really struck them. And it's always a learning experience to see what grabs the attention of different people when they read a case.
Absolutely. And I've found the more that we've done our own advocacy on these cases, we've experienced that firsthand, where an arbitrator may be quite interested in a certain point that we didn't quite see coming, and then being able to pick up on that and think, well, okay, how am I going to think on my feet and pitch to that, or how am I going to deal with that in post-argument in some way and get the opportunity in a post-closing submission, or in this case, amend the application because the case is still progressing. Fascinating. I find this stuff fascinating. It's why I really enjoy what we're doing here, Calum. I think we're humble in the process to continually learn from what we are reading and thinking about. And long may that continue. I really think it's the way you become better at whatever your craft may be, whether it's a lawyer or anything else you do out there. Continuing to learn, having that mindset of how can I learn, being open to learning, thinking about, right, I do it that way. I see that. Now this is an interesting point. So, okay, right, we've spoken about privilege probably longer than we thought we would. Thank you, everyone, I really enjoyed it.
We've hit privilege, we've hit RFIs, we've hit genderisms in 19th century judgments.
We've done well. We've covered some territory, not for the first time. Look, hopefully you've enjoyed this. We'll try and get another podcast out to you next Thursday, as we typically do. We're quickly approaching the end of the year, Calum. I can't believe we're what now, mid-November. But it's fun.
Not long until we have the Christmas jumper episode.
Yeah, that's true. We've got that coming up. Well, thanks everyone for listening in. Hope you've enjoyed it. Drop us a line if you're liking what you hear and want us to focus on some other particular type of area or issue or what have you. I'm sure we can dig out a case to touch on it. And thanks for subscribing. Our subscriber base continues to grow. So great. Thanks for listening. Until next time, take care.